All right, we're recording also. So, good evening, everybody, to those of you who are joining us from India, and good morning to those of you who are joining us from the States and elsewhere. Thank you so much for joining us today. Those of you who are joining us from India, thank you even more profusely if considering that we are in the middle of one of the worst COVID waves that's hit the country. So thank you so much for making time. Maybe if you've just considered this as an escape from all the gloom that surrounds social media and the news, we hope this will bring some cheer to you and you'll finish today on a high note with a lot of learning. So without further ado, let me take this opportunity to introduce you to our speakers, especially for those that are uninitiated. Our first speaker for the day is Ms. Reika Rangachari. She has been the executive director of the New York International Arbitration Center since 2017. The New York International Arbitration Center is a nonprofit organization that promotes and enhances the conduct of international arbitration in New York. Prior to joining the New York International Arbitration Center, Ms. Rangachari was director of the area services for the New York Commercial Division of the American Arbitration Association's International Center for Dispute Resolution. Therein, she's led the New York Corporate Innovation Team and served the Diversity Committee, spearheading initiatives for greater cross-cultural representation and collaboration. And I think that's one of the causes that's closest to her heart, about increasing not just gender, but also racial diversity in arbitration, in arbitral practice, as well as arbitrating. And the AAA ICDR Foundation Committee, which has funded over 35 projects since its launch in 2015. She is herself a 2017 recipient of the AAA ICDR President's Award for Service. She has also served as case counsel for the ICDR, focusing her efforts on the European and Sub-Saharan African regions. Beyond the AAA ICDR, Ms. Rangachari serves as a member of the New York State Bar Association's Dispute Resolution Section Executive and Diversity Committees, co-chair of the International Disputes Resolution Committee, member of the New York Bar Association's Planning Committee for the Judith K. Moot Court Competition, board member of the New York Coalition of Women's Initiatives, organizing committee co-chair of the Arbitral Women Diversity Toolkit Conference, which I'm sure those of you who've been following her on social media will know of. Ms. Rangachari is also the associate editor of the Juris Investment Arbitration Conference volumes, and I personally have relied on a lot of her work on confidentiality, corruption in investment arbitration in these volumes. She serves also as an adjunct professor at the St. John's School of Law and Seton Hall Law School, teaching commercial arbitration. Thank you so much, ma'am, for agreeing to do this. Our second speaker for the day is someone who I know very well, luckily, through my stint at NLU Jodhpur, and therefore Kabir and I go way back. But I'm going to start calling him Professor Kabir henceforth, because now I consider him a very great colleague in the fraternity. Kabir is a senior international arbitration advisor at the firm Arnold & Porter's New York offices. He focuses his practice on international investment arbitration, international commercial arbitration, and public international law matters, serving both as counsel and arbitrator. His experience includes complex disputes under numerous bilateral and multilateral investment treaties and contracts in South Asia, Latin America, Central Asia, Middle East, Europe, and Africa. His experience comes from his triple training in international law, common law, and civil law traditions, and which is why I think he's the best resource to have on the panel today, that is going to talk of both the common law traditions in the evidence taking and the inquisitorial civil law traditions in evidence taking, which is where I think he was able to also contribute to the books that he's done on this topic that we're going to be speaking of today. He also acts as a consultant for the United Nations Office of the High Representative for least developed countries, landlocked developing countries, and small island developing states on the creation of a novel investment support program, which was actually shortlisted by the GAR for the category of Best Development for 2018. He also serves on the steering committee of the investment support program. He has also conducted training and capacity building sessions for several governments, including Colombia, Saudi Arabia, Myanmar, India, among others, on public international law and dispute resolution matters. He has received even more accolades for his work in international arbitration and has been ranked as the fourth most highly regarded future leader in the Americas by Who's Who Legal in 2019, and was the youngest practitioner to be listed in the global listing of arbitrators by Who's Who Legal in 2020. He has also been ranked as among the top 10 arbitrators for the Asia Pacific region by the Bali International Arbitration and Mediation Center, and has received the 2019 Equality and Diversity Award in Dispute Resolution. In 2021, he was also awarded the 2020 Dispute Resolution Practitioner of the Year for the Americas. And alongside Ms. Rangachari, Kabir has also been part of the entire movement on increasing racial diversity in arbitration practice as well as arbitrating. So today's panel is extremely power-packed, and we are going to be learning from them about the taking of evidence in international arbitration. The panel is going to talk about questions regarding the taking of evidence as a question of substantive law or procedural law, the old IBA rules, how the 2020 pandemic led to the change in the IBA rules, as well as the IBA rules posited against the more inquisitorial Prague rules on taking evidence. And if I may maybe give you a trigger point to start your talk, and those of, I think a couple of my former students, including Ashwin, are on the meeting today. It's just something I used to say in class when I teach arbitration, that considering that international arbitration today is such a mix of cultures, and it's something that Professor Lowenfeld used to say, that they've moved from a salad bowl to a melting pot to an omelette. And one of the best examples of international arbitration turning into an omelette is how deeply embedded different evidence-taking practices have become in the practice of commercial arbitration. So take it away, both of you. Thank you so much again.
Thank you so much for being here. Now, you know, it is 9 a.m. Eastern time, and I am hungry for this omelet, in truth. But of course, we have to start in the first instance by offering our thanks to the Center for Alternative Dispute Resolution at Jindal, specifically, of course, to your professor, Akansha Kumar, for inviting us to beam into you today. She was overly generous in sharing our bios, and what we hope you gleaned from all of that is that we're really striving to collaborate across the many organizations and associations where we hold leadership positions. If you want to get involved, give an electronic shout. Kabir has been maintaining an active chat as Professor Kumar was talking, and we really mean that. We also want to add, you know, we wish the world were a different place right now, where we could meet safely in person in Delhi. Instead, what we do want to do is offer our safe wishes and our prayers to each of you. We are trying to figure out how we can build some financial support and send it to India. Professor Kumar has advised us that she'll give us some suggested and shortlisted charities, but we understand the oxygen crisis is terrible. That pandemic is now, you know, booming again there, and everyone is in a state of lockdown, separated from their families, and that this is really tough. And so we would be remiss if we didn't say, we understand what's happening there. We are following the news, and our hearts go out to each of you. With that, Kabir, if you want to take the mic and give a hello.
I just wanted to echo what Reika said. We're delighted to be here. You know, we know this is a very difficult time, and, you know, there's probably a lot of suffering, and everybody knows somebody who is impacted. If it is not just you, you are all in our thoughts and prayers. And, you know, we hope that we're able to come out of this with minimum harm and come out stronger. Subject to your professor's guideline, feel free to, you know, following whatever instructions you'll are given, use the chat to communicate, to talk, to tell us what you're thinking, you know, try and make this subject to the school's guidelines. Try to make this as interactive as you can, and, you know, you will gain more out of this session by that process. With that, let me turn it back to Reika.
So
tell her what we're going to do.
Yeah, so we're talking today about evidence, right? And why is that relevant? it becomes, you know, as we talk about this melting pot or this omelet, fabulous images being pulled there. But notwithstanding, it demonstrates also this general criticism of international arbitration: high cost, lack of speed. What is a major, if not the contributing factor to this? It's the taking of evidence, right? That cuts against time and cost. We see that in several surveys, including the Queen Mary University of London White and Case survey, just to name one. And so we've come into this era of we need to be more efficient, we need to be more transparent. What does that mean in practice and not alone vested in theory, right? And so with that, in order to have a conversation about improvement, in order to have a conversation about too much or too little, we have to start with an understanding of the frameworks which you've all learned about, but we're going to tease them out. And to that end, please, respecting the protocols and procedures that your professors have given you, posit questions as they pop up into the chat. It makes it more engaging. It allows us to deal with it in time if it's appropriate. But of course, we'll save questions for the end too, because I know we'll have a very robust Q&A session thereafter. So with that, let's get into it, shall we?
Okay, so we're going to start off, as Reika said, talking about the framework for the taking of evidence in international arbitration, right? This is intended to help us understand at a high level how arbitration looks at evidence. Think about this in contrast to what would happen if you were going to a court. That's your point of comparison, right? Once we understand this framework, we're going to be looking at two distinct areas. Now, there are many areas we can talk about. We have selected document production. We have selected standard of proof. We thought those would be good illustrative points for us to focus on. So those will be the two sub-points, and then we can have a Q&A. Okay, we're going to start off with the story, and this is a real story. I don't want to admit my age, but this happened a very long time ago. I am out of law school. I'm in my first job in New York, not in this office, but not very far from here. We are representing Venezuela, the country, right? So it's an investment arbitration. Again, here, don't worry too much about investment and commercial because the framework remains the same, whatever form of arbitration you're talking. We're representing Venezuela. Okay.
Kabir,
Yes.
do you have to change your slide maybe?
I am going to change it. Yes. Sorry. I was building a dramatic take-in, but I will. You remind me to do that.
No, I thought maybe the screen froze and we can't see.
No, this was me building a dramatic story.
Okay, I'm sorry. I'm so sorry I interrupted you. Please go ahead.
You're not interrupting. Keep joining in, and we invite all of you. Akanksha, at any stage, join us, in the conversation. Ashwin, Shantanu, join us in the conversation. Every perspective here will enrich the discussion. So we're representing Venezuela. We have appointed a particular arbitrator. If you know investment arbitration, she's a woman and she's French. She's one of the, for people who know, you can make the connection. So we have appointed her. And I'm like, in the practice very early, and we get this motion from opposing counsel that they are challenging the appointment of our arbitrator. Now, this is true. Sometimes the craziest things are true, but when we start reading the motion, we are told that Venezuela and Bolivia are going to merge to form a new confederation called as Bolizuela. Okay, this is a little over $1 billion in dispute. So chump change, so to speak, right? Okay, in this dispute, we are now being told there's this new confederation, and we are told this is the announcement of the confederation. Okay, but it goes on and on and on. We're told what the national bird is going to be, what the national animal is going to be. We're given representations of the new currency of this new country, right? What is the argument being put forward? The argument being put forward, right, is This is something you should be familiar with, right? In arbitration, you don't want a party to have a friends and family relationship with the arbitrator. I cannot keep appointing Akanksha, right? Because that gives Akanksha a perverse incentive to rule in my favor. So soft law guidance tells us something like 3 times in 5 years, you're given some magic number in the IBA, right? That you don't want it to become, Akanksha shouldn't depend on Kabir for appointments. The argument here being made is, you need to count the number of times Venezuela has appointed this arbitrator and Bolivia has appointed this arbitrator. And if you added it up, it was like 20 times. She, this arbitrator is a state lawyer and the number is 20. It's just ridiculous, right? So the argument is this arbitrator should be disqualified, right? We're looking at this, our jaws sort of drop. We were like, how could we have missed this announcement? And then at the bottom, they had a footnote and they're citing a blog called as Democracy Now, right? So all this is taken from this blog, Democracy Now. And Democracy Now tells us, when you look at that website, for further news, click on the New York Times article. Now, I vividly remember this as a young lawyer, innocent. The law practice has not destroyed me, clicking on that link, and this is what popped up. Okay. Now, why are we pointing this story out? This is a serious legal proceeding. Okay. This is what is put as evidence for what is a serious challenge. Now, let me just tell you a few more things that are relevant and I'll pass it to Reika. This motion will go on. We will have 4 rounds of submissions, 2 each, right? Claimant, respondent. We're going to have a hearing. This motion will obviously get dismissed, right? You're not going to, on an April Fool's Day, allow somebody to prevail. The motion gets dismissed, but we don't get costs. Now, this is the question I'd invite you all to think about. Try doing this before any Indian judge in any Indian court. They are not going to look at this favorably. If you did something like this, the answer would be anger, disgust, surprise, or even threatening to disbar you. But this is okay in arbitration. Why is this the case? Let me pass it to Reika to tell us a little bit about the evidentiary framework. Reika, take it away.
Sure. So why is this the case? How do things like this come in the door? And it comes back to when we look to general provisions, right? There is a necessary ambiguity as we are hopping cross-border. When you amalgamate, you necessarily need to, in some ways, go more general, go more broad. And by going that route, how do you give credence to the words that are provided? So we're going to take a quick snapshot here. We're looking at ICSID, we're looking at Arbitral, and we're looking at the ICC notation here. ICC recently updated rules. In truth, as it pertains to general provisions, no big delta in changes there, right? And we ask you to think about this as we go through them in the context of the Indian Evidence Act, right? Lots of rules, lots of exceptions. You know, how do you work your way through it? Is it better to have more generalized rules? And that's really the quandary, right? Specificity of form or generality. How do we get better in the practice? Okay, but let's take a look, right? Overall, you're seeing great authority given to the tribunal, right? Under ICSID, tribunal may, if it deems it necessary, right? Under the Untitled model, again, all of these notions that the tribunal is assessing as to admissibility, relevance, materiality, and weight, but discretion of the tribunal. That's the biggest thing we want you to take away. And then, of course, the ICC rules updated at any time during proceedings. The tribunal may summon any party, right? Full discretion given to the tribunal. Why is all of that important? It becomes important in the context when you're mapping a general framework under the rules that then ally with soft law to give us context. What does it mean? How do we formulate this in our practice? How do we give it context? And so with that, I'll pause and pass the microphone to Kabir to take us into an introduction, not only of these frameworks, but into the soft law that gives more credence, right? And the application of it. Kabir?
Thank you, Reika. So I think, folks, this is what you should be doing. This is exactly what Reika tells us. We're told discretion. That's the big thing the rules tell you. Tribunals can do what the tribunals want, versus think about the Indian Evidence Act. Think about the rules, the exceptions, the case law. There's a reason why most lawyers hate evidence. It's like math for lawyers as well, right? We hate math, we hate evidence, very technical. This is where soft law steps in, as Reika tells us, and we're going to look at our first soft law instrument, the International Bar Association, the IBA. You should probably know this. It is not a bar in the state of the Bar Council of India, the Bar Council of Maharashtra and Goa, any of the states. It's a voluntary organization based in London. Since it's based in London, you pay them a lot of money and you can join. Anybody can join. It's a voluntary organization. And one of the things that they do is that they will periodically come up with soft law instruments that have gained a lot of acceptance throughout the world. The instrument we're looking at, the soft law, is the IBA. We call it rules, but they're really guidelines on the taking of evidence. Okay? Now, this is a case in point because you will hear Reika talking about another soft law instrument very soon in response to the IBA rules. But the IBA rules are sometimes presented as a common law instrument. Common law following the Anglo-American tradition, like India, right? Let's circle back on this, but just keep this in the back of your mind because this is relevant for the debate. Okay? So these are non-binding rules. Whenever you hear the words rules, just in your mind, remember guidelines, wink, wink, right? For efficient economic and a fair process for taking evidence. Key word here is process. Evidence can deal a lot with substance, right? What is hearsay evidence? When can hearsay evidence be admitted? What do you do with corrupt? The IBA is not going to tell you an answer to any of that. The IBA is a whole 9 articles. That's it. So again, compare it to the Indian Evidence Act, the IBA falls woefully short, right? They were actually issued in the earliest iteration in the 80s. 1999 was the major iteration. 2010, they updated it to make it investment arbitration friendly. 2020, it was updated again, okay? 2020 doesn't do anything remarkable. So if you're looking for world changing, you're going to be disappointed. Professor Google will give it to you. So go to Professor Google, you will find the IBA rules. Reika, I don't see the chat. Is it on the chat?
Oh, I'll put it in.
Okay, yeah. So just take a look at it. One big thing they do is they now allow virtual hearings. Surprise, surprise, like all of us, hearings have moved virtually. Okay. Now, I was party to the 2020 amendments. I was part of the subcommittee along with 60 other people. For 9 articles, it seemed excessive. But the idea here is to have global participation because it helps build legitimacy, right? That's the idea. Now, here's a key point. If we look at the composition of people involved in the drafting of the IBA, the greater number come from civil law countries. Now, what is the difference between civil and common law at a macro level? Okay, civil law countries follow Roman law, and in the Roman law tradition, the approach you would use is inquisitorial, where a judge, for our purposes, arbitrators in the same position, are responsible for the truth. So there is an absolute truth, and a judge, not the lawyer, seeks the truth. Now, let me just give you one example. This used to be the situation in Brazil that Reika and I discovered when we were speaking to Brazilian students. Till 5 years ago, a lawyer couldn't cross-examine a witness directly in Brazil. Just think about this. A lawyer asked the question to the judge would rephrase the question and ask it to the witness if the judge thought it was a good question. That is the inquisitorial system. Now, that is an inquisitorial system on steroids, but that's an example. But no document production. You present your case based on what you know, right? Contrast that now with the common law approach. And the common law approach is lawyers fight it out. The judge supervises, but the judge is really watching the show, the adversarial system, right? Now, critics are going to tell us that the IBA is adversarial because it has assumptions that are common law. And two ways that we will see this is there is an acknowledgement that a party can present a witness. This is what critics will tell you is a common law assumption, and that you can seek documents. You will hear more about this from Reika, so I will not ruin her thunder, but just keep this framework on the adversarial versus the inquisitorial system. The IPA was not intended to be a common law. It was intended to be a marriage between civil and common law. That's how they would see it. Okay, Reika will tell us very soon about the reality of how others look at it, but this is what the IBA will tell you. And the underlying value here is that the parties will act in good faith. Now, read the IBA rules. Professor Kumar has told us you're going to be asked this in your exam, so I'm kidding. Reika, take it over. So we have the IBA. What's the response?
Right. Well, so, and, Kabir has charted, very systematically this idea, entry of the IBA rules, they sort of became the hegemonic reality of soft law without any other sort of document to contest it, right? We see an evolution of the IBA rules under a 10-year span, right? Kabir charted 1999 and then 2010 and then 20. And so we're seeing a lot is happening in our practice that the IBA rules are trying to grapple with, this notion of admissibility of evidence. But in truth, in giving this power back to the counsel teams, right, to the parties, instead of to the tribunal or the judge, right, there ended up being this commentary of backlash. Why has there been an Americanization of our process? This idea of evidence and examination, it's much more in the common law system and specifically even in the American system. And we, in spite of the drafters being my Riyadh backgrounds, we want to take away this sort of gloss on it. We want to get back to the inquisitorial reality. And in truth, take note, the Prague rules initially were titled the inquisitorial approach as a means to demarcate very directly. We are going to do it differently. We are going to take the departure, right? And so what are we seeing in the Prague rules in general, right? We're seeing this notion of an active tribunal at all stages, right at the outset in the case management conference. They're the ones who will clarify. They're the ones who have the discretion. Of course, they always had the discretion, but very overtly as identified into the rules. They also have the option to share preliminary views with the parties, right? It's a way also, what had become under the IBA rules, one of the other critiques was when you have this Americanization, right? You also have this very large fear of the due process paranoia, right? And so in the due process paranoia, you allow the timetables to be expanded, you allow more evidence in because it's that fear of you don't want your word to get set aside after all the work has been put in. And so it's a means towards economy, right? That the Prague rules tried to say, no, the tribunal can decide, they can be definitive, they are very actively involved in all stages, full stop. And so they're cutting against then trying to get our process better, right? They're addressing the expense, they're addressing the document production issues. And so it's this shift away. It's renamed instead of inquisitorial, that was maybe a bit too brash, right? They said, we're going to call it the efficient conduct of proceedings as we push towards this process. And so what we want to ask you is, as you think about the interplay between the prog rules and the IBA rules, whether the prog rules are indeed reactionary to the IBA rules, many would argue yes, but more importantly, right, the IBA rules have been around for such a long time that they've become common practice, that we adopt, that we see it, right? And so the question then becomes, we haven't yet seen the tip into the prog rules, right? The application of the prog rules, because as we know, with any update of rules, it always takes time. Just in a similar vein, when you amend and update an arbitration clause, it takes time before those disputes percolate, and then you see how active that clause is. Is it better because of the amendment? So it's really now a time of great scholarship to think about in theoretics, how will these play out? Having optionality of soft law, does it make the practice better? Another question that some have posited, will there ultimately be a third set of rules, right? An amalgam of the prog and the IBA to get us somewhere into a closer middle ground? Who knows? But these are the things that we want you to think about as you look and compare directly the prog rules to the IBA rules, right? There are critiques for everything. And so you as the students have to bring the critiques. You have to think critically as you map them against one another. We're going to go into the rubric of actual, what is document production? What does it mean to go through that process? How did these rules, how can they apply? And take some case examples. But keep thinking about looking at these against each other. And I offer this not as self-promotion, but in one of the articles Kabir and I have written about the prog and the IBA rules, a big thing we really wanted to do to make it clear and easy for us is, let's just do some charting. Let's do a comparative review. Take one clause, take the other clause. What do they say? What would be the outcome, right? But keep thinking about this, because what we're really curious to see is the implementation of the prog rules, and then in the practice, how do we evolve with it? But I'll pause there and pass the mic back to Kabir.
Fantastic. So folks, do what Reika has encouraged you to do. One point of distinction you want to be keeping in your mind as you're looking at the application now, what we're going to delve into, you want to be thinking about domestic law versus international arbitration, right? Indian Evidence Act versus rules. The second thing, within rules, you want to be thinking about IBA versus prog, right? What is better will depend on what parameter you're using, right? Do you want better control of the process, or are you looking at costs and time, or are you looking at well laid out rules? The parameter you decide will probably give you a different answer. But keep thinking about this as we delve into our two application points. We're going to start with document production. Reika and I here just want to make a general call. This should be an easier point to convince the younger generation. I have the wall of shame here when it comes to paper, but we all need to consume less paper in arbitration. In law at large, but in arbitration in particular, we use too much paper, and it's unacceptable. And we're going to find pressures to stop doing this. With that, let's start off looking at the IBA guidelines and what they tell us when it comes to documents. Now, the first point here you need to keep in your mind is, when you think of documents, you're often thinking of something like this, right? Paper, book. The IBA's definition of document includes things that we would not think of as documents. CDs are included, emails are included, the maps are included. The definition is much broader. And this next point is where you will see the common law sort of assumption stepping in. That is, if you are in a dispute, you may need documents from the other party, and you can seek them from the other party. Now, I have never practiced law in India. I'm just curious to know, in India, in a dispute, can you seek documents from the other party before a court? Anybody know the answer?
Yeah, Ashwin, batao.
Ashwin, step in.
The evidence law teacher.
Evidence law teacher.
Well, I couldn't hear that last bit.
Can you see
Can you hear me?
Yeah. Yes. I don't think he can hear us. Can you hear us?
I can hear you. I can hear you. Go ahead.
Yeah, the question is, in India, in a court proceeding, can you seek...
Hello.
Ashwin, can you hear us?
We can hear you. I think Ashwin is
Hear
struggling
you.
with
Yes, please go
bad
ahead.
bandwidth. Yeah.
Sure. I mean, the question is really, in evidence in India, can you seek documents from the other party in a court proceeding?
There is a mechanism in the civil courts, but that's essentially under the Code of Civil Procedure, where you can ask for a process of discovery. It exists within the scope of law itself.
Thank you. I mean, that is the only thing we needed to know. And we see India as a common law country following the common law assumption. You can gain documents from the other party, right? There is a mechanism to do that. Contrast this with Germany. In Germany, you can never, ever, ever, to quote Taylor Swift, seek documents from the other party, right? This is the common law assumption here. You can get documents, but the IPA restricts it. The IPA tells it's not going to be the American give us everything, right? In America, when you want a document, it's just email the other party, give us everything, and you get everything. You often get boxes and boxes. You may not know this in practice, but everyone has seen bad Hollywood shows and seen ridiculous Law and Order kind of episodes with the boxes coming in, and that is true, right? So the IBA tells us, no, if you're requesting documents, you need to identify them. They must be narrow and specific. You must justify that they reasonably exist. You statement of how it is relevant to the case and material to the outcome. You need to give a statement that it's not burdensome, and you need to state, why do I think that Akanksha has the documents? You have to justify what you are seeking, and the process here is, by laying all this out, you're making it difficult to ask for generally interesting things. In practice, this takes the form of a table. Now, if you are an arbitration associate in your first year, you spend a lot of time working on this and it is woefully boring. But this is what you will do. You will create these Redfern schedules. Column 1, you fill in telling all these criteria we spoke about, you put it in column 1. I'll give it to, in column 2, I'll put in the reason, right? Then I give it to Akanksha. Akanksha will fill in column 3. This is whatever I have said here, she's going to say the opposite. That's the rules of the game, right? If I'm saying yes, she's going to say no. This is the adversarial approach. The tribunal is going to look at both our arguments and give the reason. Produce, don't produce. Produce, don't produce. Your Redfern schedule can run into hundreds of pages, right? Because you have to make it narrow and specific. So you will say, give me the minutes for the meeting in the month of July. That's one request. Next request, give me the minutes of the meeting for the month of August. Now, if you're doing this for 2 years, think of the number of requests. You're going to get 24 requests just on minutes. Then if you want the agenda, it's another 24, right? And for each of them, you have to give what becomes pretty rote explanations. So these tables just become longer and longer and longer. Lawyers bill by the hour, so it doesn't matter. Clients pay by the hour, and it greatly matters to them. This is where the problem comes up. Reika, now the tribunal gives us the decision. What happens if we, and by we, obviously the clients, because as lawyers, we are very ethical people, don't comply with what the tribunal tells us to do? What is going to happen?
So tricky, right? What happens with non-compliance? And it's not a clear, bright line rule, right? Because the truth is, A tribunal, for example, can take formal note. They can draw an adverse inference. They can treat future evidence with a degree of skepticism. They can have an effect on it in the allocation of costs, right? This idea that if you've hidden the information, you've failed to bring it forward, it must be so bad. The truth, though, is tribunals are reluctant to make these sort of adverse inferences, right? A finding and a negative effect that it can have on the case, ultimately to get litigated or relitigated, right, outside of the arbitration process. And for this reason, then, great discretion again comes back to the tribunal. Loose rules. You don't need to lay a foundation for the documents, right? They're presumed to be true. And so when you have these broad sort of rules, this easier access, non-compliance becomes a larger issue, right? But again, tether that against extraordinary factors, tribunals' reluctance. And so also in this context, because we're always trying to tee everything together, we want you to be thinking about what are the assumptions within the PROG and the IBA rules that speak to document production, right? In the PROG rules, it assumes no document production as a reactionary reality to the IBA rules. The IBA rules assume document production, right? And so the IBA rules, although they may try to restrict, they let it in. Ultimately, the PROG rules permit document production. So where do we get? What is the there? And this we say in jest a bit, right? The truth is, both rules want a set of open processes because party autonomy is what drives international arbitration. And so we need to underscore that always in everything that we do. But then how do we get there when parties misbehave? One level of misbehavior is non-compliance, right? But with that, Kabir, give us some more insights on this.
Reika, I don't think I have much more to add here because I think you put it very nicely. The IBA and the PROG ultimately take you to the same destination. They're just going to take you through very different routes, right? The initial starting assumption when it comes to document production, witness testimony and all, end of the day, you see the outcome is the same. It's just the assumptions to get there. So I think we present in front of you, again, this is going to show up on your exam, so very important. But this is just one illustration of how you see the difference in front of you. With that, let's quickly try to get in and out of our second so we can have some time for the Q&A. But the second aspect we're going to be talking about, and this is now getting into the substance, right? IBA is silent, PROG is silent, arbitral rules are silent, right? So where do you find out substance? And that's what we're going to be talking about when we say the standard for wrongdoings. Okay. We're told, now think about this, when you look at the Evidence Act, you don't study them as such as standards when we're studying Evidence Act, but this is what we are being told. This is what a party needs to prove, right? That's what we're talking about when we say standard. Everybody knows the criminal law standard beyond reasonable doubt, right? What is standard telling us? Standard is telling us how much. How much evidence do you need to produce to convince the judge, the arbitrator? Contrast standard with burden. And burden is telling you who must produce the evidence. Okay. Now, burden, the answer is very simple. The one who says proves. So if I am saying the earth is flat, I have the burden to prove that. That was the case for a very long time historically, right? But I have the burden to satisfy the judge, the arbitrator. So we're not going to look at burden, except just keep this in mind. If Reika, if Akanksha are coming forth with a defense, if they are coming forth with a jurisdictional challenge, they are bringing the motion, they have the burden there. So it's not always the claimant. The burden can move based on who is putting an allegation. Now, the party that has the burden must meet the standard of proof, the appropriate amount of evidence. And we're told that the evidence, to use common law terminology, is preponderance of evidence or balance of probabilities. And these are both common law terms you should be familiar with. What does this mean numerically if you're thinking about it? 51%. That's all. That's what's going to apply. This is not a criteria you can use in exams. Okay, 51 is not a good percentage, but for civil matters, this is what you're trying to tell. If I am giving a version of the truth, if Akanksha is giving a version of the truth, the judge, the arbitrator, is going to see whose story is more likely to be true, comparing the two versions. And our versions are going to vary to come to the truth, right? This is what the civil lawyers will call the inner conviction test, the inner judge test. Same idea, 51%. The judge is going to hear both stories, and whose story convinces me from within. That's the inner conviction test, right? This will apply almost everywhere in arbitration. It's civil law, as you know, it's civil matters, it's not criminal law, except in a limited situation where a heightened standard will apply. Now, when do you apply the heightened standard? You apply it for quote unquote serious matters. And what do we mean by serious? Think of it more as quasi-criminal activity, bribery, fraud, right? There you don't want to make it what Kabir tells you versus what Akanksha tells you. That's not good enough. These are serious matters. So we're going to heighten the standard. We're not heightening it to a criminal law standard. It's not 100%. But if you're thinking of it numerically, think of it like 70, 75%. We're going to look more vigorously with more rigor at the evidence. And we're going to look and see how this heightened standard applies by looking at two cases in and out. I will give the first case to Reika to talk about. It's probably the most entertaining case in arbitration, the World Duty Free versus Kenya case. Reika, take it away.
Sure. So I'm sure many of you are familiar with this case. Lots of notoriety here, right? Quick summation of the facts. An agreement investor enters into 1989, construction and operation of duty-free complexes, right? 10-year renewable for an additional 10 years. But what happens, right? And that's what gets really interesting, right? So the investor alleges that as part of the re-election campaign of the president, that there was this ask, right, that money is supposed to be funneled in this sort of cultural notion of private donations for public purpose. And so an ask of $2 million in cash to the president, a personal donation, payment for doing business with the government of Kenya, right? So interesting facts and truths. Why is this case interesting? Because we're teasing out some really interesting aspects of transnational public policy, looking to many aspects to figure out what does public policy mean, right? We looked at international conventions, declarations, national court decisions, trying to find standards, which is how we started in the first place, right? We talk about evidence, we talk about the framework, we talk about standards. What are the standards when we have bribery and we have culpability? And so the joke out of this case, right, is, you know, it was the most expensive corn that was purchased, a suitcase with money deposited outside at an appropriate venue, and then on return, when it's reopened, it's filled with corn. So, you know, hopefully that corn was really tasty. But the root of this discussion really gets to what is an objective view of transnational public policy, right? How do we address culpability? What is an objective minimum standard of conduct for the investor? Appreciating that corruption may exist at the state level, right? But what are the obligations of the investor? And so when we look to that, right, it becomes this idea of corruption as a jurisdictional barrier, irrespective of what's happening in the host state, that the investor participated. right? And then how do we deal with proof in examples like this? And so we're trying to tease out, right, when we get into it, it can be really tricky. It goes back to that April Fool's Day example that Kabir first shared with you. This is tricky stuff where standards are general and maybe even ambiguous necessarily to let things in, but then how do you address objectively culpability of the investor as against corruption of a host state? So we really want you thinking about these things as we go through the different examples that we're going to look at. And the next case up, after Kabir can weigh in on this as well, we'll take you into metal tech to have a broader discussion.
Thanks. I mean, just only trivia point. World Duty Free is the company you see at all airports. Just pointing that out. Second trivia point. The applicable law in this case was Kenyan law. And the tribunal will look at every law except Kenyan law. Or they do what arbitrators often do, which is horrible. Because we see that happening with India too. Kenyan law is English law. Let's look at English law. Haha, and the analysis is under English law. We see this happening with India too. We've now been independent for some time. Can we focus on Indian law if that's the applicable law? But that's another macro issue I just put out there for all of us to think about. Okay, let's look at our final case, Metal Tech versus Uzbekistan. And here you have a joint venture, right? The argument here really is there a bribe being paid to the government? And what is the bribe in question? The bribe in question is there are 15 consultants for the company that are being paid a lot of money. More than the investment is the fees to the consultants. Who are these consultants? These consultants are friends and family of the president. Okay? And what are the consultants doing? Nobody knows, right? The tribunal keeps tell us what these consultants are doing. Tell us what these consultants' purpose is. Now, I just posit this as a question. The claimant kept saying the work of these consultants is legitimate. Now, in the US, if you go down K Street in Washington, D.C., entire K Street is lobbyists. Their job is just to lobby with the government. I wonder if the claimant had said that these people are lobbyists, whether that may have led to a different analysis. But they kept saying, no, the consultants are legitimate. Here you can just see the idea. 3.5 million is being paid to consultants. $500,000 was the investment. That does sort of look icky, right? End of the day, the tribunal here is going to adopt what we call as red flags. Red flags are not definitive proof, but you are looking at a variety of factual situations, combining them and coming to a conclusion that the money was a bribe. Since it's a bribe, the tribunal has no jurisdiction and the case gets dismissed. Right? Is this an ideal way for us to be solving corruption? Think about it. Think about the reality that, you are very seldom going to have proof of me giving money to Reika. Right? That is definitive proof. Right? Photo of me giving money, a check to Reika, leaving the bag out. You're not going to get that. So should we be using red flags? Another question you want to think about is, the case gets thrown out for corruption. The state has also received a bribe. This is sort of benefiting the state. Well, not the state, well, at least state actors, but should we be penalizing state actors and the state, right? Hold the state accountable, right? We do that when it comes to the law of war. You can't say, oh, individuals told me to do it. If there's a breaking of the law, there's a breaking of the law. Should we be thinking about something different in comparison to how the law has developed? With that, yeah, we have the case here, telling us at the end of the day, you violated Uzbek law because bribery is a bad thing. That's their essential finding. Okay, we're going to stop here and we're going to open it up subject to your professor's comments. We can take questions on the topic. If your professor, is interested, we're happy to answer any question more generally, but your professor
Definitely.
sets the parameters.
Definitely. I think I can hold out my questions because I'm sure the audience will have a lot to ask and say and comment. So we can open the floor to questions. You just to streamline the process, please use the raise hand function. It's under the reactions button on the bottom or the top of your Zoom interface, whatever you're using. If you're unable to locate the raise hand function, yes, Sagar, I will get to you. If you're unable to locate the raise hand function, please just type out your questions, or you can just leave a message to me on the chat box and I will call out. Yes, so we can go with Sagar first and then we can go with Avineet. I think Sagar disappeared though. Yeah, Sagar, you can ask
I'm
your
here.
question.
Yeah.
And hi.
Thank you. Thanks,
Wow.
ma'am. Hi. Thank you for organizing this, and hi, Kabir and Reika. Good to see you. I mean, just as an aside, I mean, as ma'am mentioned right at the beginning, I remember Kabir about 5 years ago, and that really discloses my age and yours. When I was a student,
and how ancient I am then.
you had given us an overview of investment arbitration. But just two quick questions from me. The first is around the Prague rules. Do you think it's just a matter of time before the Prague rules are in fact going to be adopted? Certainly in practice here, I haven't seen an arbitration where sort of the Prague rules were adopted over the IBA rules. So is it that, or do you think the Prague rules are going to die unsung death, as it were? That's the first. The second is, I mean, again, this is just PIL 101, right? I mean, I think in the ICJ, certainly the standard of evidence is clear and convincing. So it's not balance of probabilities. It's not beyond reasonable doubt. So, and that's a standard that we have seen in the era where ICJ judges used to act as arbitrators in investment arbitrations. That is something that was adopted as a standard. And I noticed on your slides, you say that the balance of probability standard has become the default. So, I mean, how are they engaging with this PIL standard, or has there been a change specifically in the standard? Thank you.
Sure, thank you. You made a twofer there, huh? Okay, I'll give my reactions and I'll pass it then to Reika to give her reactions. On the Prague rules, if you talk to the organizers of the Prague rules, they tell us the rules are being adopted. Arbitration is confidential. The only way we know whether they're being adopted is to hear anecdotal evidence, and the organizers, albeit a biased audience, tell us they're already seeing acceptance. Okay. I mean, I just put a meta question. This is something actually Reika had raised. So I'm going to talk about Reika as though she's not present here. But, Reika's point has always been choice in life is a good thing. You don't have to exercise the choice, but having the choice is a good thing. And the fact that you're giving a choice here, don't use it, modify and use it however you deem appropriate, pick up 2 articles, you now have competition. So that's a good thing. Reika, do you want to add anything there? I spoke about you like you're not present.
No, I think you covered it. The tough thing is seeing acceptance, digestion, consumption of the Prague rules is tough. It will take some years to even assess. A lot of effort went into it. I'm sure they'll also go through their own set of revisions. And so the question becomes, when will we get to see it, right? We'll get to see it in enforcement realities or through general commentaries of people who have seen them in practice. And frankly, it will be a stay tuned. The lobbying body of the Prague rules is strong. And so to their credit and their advocacy, I think we'll see it. Whether or not what they're saying of it, it's being put into cases. Because I've also asked other folks and they've said, no, I haven't seen it yet. So who knows? But I think they're here to stay, at least in some form, as Kabir said, towards optionality, towards competition, towards maybe a third route. But let's see. Let's wait and see.
On your second question, Sagar, I don't think PIL gives us one standard, neither does the ICJ give us one standard. And I think this is the slight risk we have with a body that has general jurisdiction over a variety of areas of international law. The clear and convincing evidence standard, generally, both in ICJ and in investment arbitration, apply for serious matters. ICJ has a lot more of those than investment arbitration, right? We're talking about war, we're talking about genocide, we're talking about borders being changed. There you apply clear and convincing evidence and it makes sense. You apply that as one of the formulations for the heightened standard in investment arbitration, right? That is not going to be a standard you're going to apply when you don't have heightened situations. Now, in the ICJ, by nature, a lot of things are going to be heightened, but not always the case. You can have disputes that are not serious in the sense of life, liberty, and mass death or borders being changed, where you will not apply that same standard. You will apply the preponderance, you will apply the balance of probabilities. That is the default for us in investment arbitration because that is what you're dealing with in most cases, right? Was the contract breach? Was my property expropriated? Right? So I think long-winded way to give you an answer. It'll really depend on the nature of what is in dispute in front of you. Reika, any reactions?
Yeah, I think you hit it on the head, and to me, this beckons a sort of query deeper into the criminality of the situation, right? These standards exist for a reason to address real things that happen. The worse they are, the interesting scrutiny we apply. But criminality doesn't embed into everything, and so we need these distinctions. But I think it's a really good question because the shifting standards are what often cause confusion in an academic setting when we're having a theoretical conversation with students. They're like, well, which do you apply and when? Is there a framework? And this is where it gets tricky, right? Because it's a sliding scale. So there are not always easy answers to this. And that's why you get an amalgam of responses when you look at case law and you survey it.
Thank you. Thanks so much.
Sure.
Avineet, you can ask your question. Avineet is a colleague with us here at JJLS.
Hi, Avineet.
Hi, Dr. Kabir. Hi, Ms. Reika. My question is in particular with the virtual hearings. Like, you sit as an arbitrator and as evidence is being recorded online, even the examination and cross-examination of witness is being conducted online. Now, my question is, does virtual record of evidence through video calls, will that affect the relevance and admissibility of the evidence in front of arbitrators? Because the reason why I'm asking you this question is, so I was having a conversation with Mr. Toby Landau. He said that a lot of senior arbitrators say that while recording the evidence, it is very important to make an eye contact with the witness. Because as you were talking about the inner conviction test, it helps you determine that. But as if we are talking on a video call, let's say if Dr. Dugal, you are the arbitrator and I am the witness. Now, if we are talking and I am actually looking at the screen, I'm not looking in the camera, and you will feel that I'm looking down somewhere to your chin or to your shirt, right? And vice versa. And there is no eye contact happening over here. Will that affect the admissibility or relevance of the evidence?
Reika, do you want to take it? Do you want me to take it? What order do you want to go?
Why don't you start with it? Because I think virtual hearings are something you've actually been doing and seeing, and then I can comment back.
Sure. Look, that school of thought has existed. I will note it tends to be a generational thing. Are things better in person? Probably yes. Is it going to be doomsday if we're doing things virtually? I think the answer is no. Subject to good sense, having good internet and having good protocols in place, there are many advantages You have to always do cost benefit analysis of what is better rather than flying, getting people in a room, sitting down, all that, right? I would suggest, on your point, Professor, on your point particularly, I have two screens. Right now, Reika is blown up on my screen in ways that blown up. It's a big screen and her face is blown up. I'm going to be able to see her expressions here much better than I would do if we were sitting in a room where if I was doing the same thing, you may think it is what the criminal law offending the modesty of a woman. You're like a pervert staring at somebody. That was a bad joke. Right? But
That was a Kabir joke. That was a typical Kabir joke. I'll transport it back to 2017 April.
There are a lot of these. But this is the point. You can look at expressions just as fine. You need to know how to make and how technology works. And you need to set common sense parameters. Reika can talk a lot about those because she has been involved with a lot of those. But again, I don't need to, stare into your eyes to know whether you're telling the truth or no. As long as I can see how you're responding, the confidence, hear the modulation of your voice, you're probably going to get a reasonable assessment of things. Reika, I stop here.
Yeah, preference versus functionality are sort of two buckets, right? Lawyers prefer on assessing testimony as well as the tribunal. As one lawyer told me the other day, I want to see their feet wiggle. And I said, okay, that's like, in this day and age with cameras and the 365-degree views you could ostensibly see their feet wiggle. But it's that idea, right? It's visceral, it's palpable. I'm in the room with you. I am doing this. If I were to admit, Kabir and I are both, lawyers who are also trained in the US, there's very much an Americanized, like, I want this testimony and I'm going to be there and I'm going to control the cadence and the path. And that is easier to do, right? This goes to preference. Towards functionality, at the end of the day, we have nuanced the way that we practice towards needing to get justice, and we have pivoted. The law field, each of you, I just can't underscore this enough as students. You have learned how to do it with a flexibility that is phenomenal, and you will take this into your practice. This aspect of virtual, or better said, remote, right, is not going to go away. We're going to go into hybrid. We're going to figure out how we can connect offices between Delhi and New York and Hong Kong and Singapore and Sao Paulo, because it doesn't make sense to get everyone together in the same room always, right? You need necessary people there, yes, but you do not need the whole gamut of everyone. And so at the end of the day, if there's going to be witness tampering, right? If there's going to be controlling of their testimony, it's going to happen. And we have to bring good faith into our practice. This to me is the biggest. We learn it in law school, we learn ethics, we take, annual or some aspect tests on this. We ultimately have to bring that to our practice, that credibility, so the witnesses understand that they are under certain rubrics. And of course, the tribunal will set a framework, right, within their procedural orders of this is what we expect. So anyway, I just think it's not going to go away, that you all will have to learn how to be engaging in a digitized format. This is the wave of the future. It will not replace in person. But certainly, if we're going to keep talking about economy and transparency and these words that to me are super important, but are just highfalutin because I don't understand how they apply in our practice yet, but every conference has a panel on it, we have to actually mean it. And we mean it by figuring out how to reduce cost, by figuring out how to make arbitration actually an appropriate access point to justice, which it has become in the pandemic because courts were closed, national courts were closed. How amazing. It's been a rejuvenation of all these things that we love. Let's keep it that way, right? In the best way we can. And obviously people will want to naturally pivot back, but is it really a question of due process? Or is it something larger on preference? And I leave it with you because we'll do it differently across jurisdictions.
Right. Thank you so much. Yeah, thank you. So there are two questions on the chat. I'll take Shantanu's first because my question kind of adds on to what I was thinking of, adds on to what Shantanu was saying. So I'll just read out Shantanu's question first. It says, since we discussed cases involving allegations of corruption, I would like to get your views on who bears the burden of proof in investment cases, where the state raises an illegality corruption defense to contest jurisdiction. Also, if and under what circumstances would the standard shift from the state to the investor? So I wouldn't have maybe phrased it this way, yes, but my question was fairly similar. That one of the cases that we ended up reading and then teaching for investment standards of party misbehavior is the infamous Indonesian Himpuna saga, where one of the arbitrators was threatened with a kidnapping, was taken away, the tribunal got truncated, the tribunal still acted. But that's a brilliant case study on the standard of evidence vis-a-vis the burden of proof style evidence that gets taken in investment treaty arbitrations, where the misconduct or the misbehavior, as Reika was putting it, is on the part of the state host state party and not the individual investor party. Yeah. So maybe we can take that. And then I have one more question that's come on my private chat, so I'll then relay it to you.
I'll give the floor first to Kabir, I think, because his practice is so much ISDS, and then we'll have a discussion. Please, Kabir.
Sure. Let me give some initial reactions to it. Point number one, any party who is raising an allegation proves it. So if I am the state alleging corruption, I have the initial burden to establish a claim for corruption, right? That's my burden. If I'm contesting jurisdiction as the state, it's my burden, right? Now, there is no reversing the burden of proof. In fact, reversing the burden of proof is a ground for annulment and exit, but it's also a basis to challenge enforcement internationally. What can happen is, this is what we call the ping-ponging of evidence, right? The state is raising an objection, putting forward its claim. You put it in your memorial and jurisdiction. The investor then responds to that claim in its counter memorial, right? This is how the parties are presenting their respective cases, giving the tribunal the information to see, whether you're meeting the appropriate standard. So that's how the evidence will go back and forth between the parties. But you don't reverse it in the sense, if the state is raising an argument, I cannot come, there is corruption, Reika has to prove it. That cannot happen. I have to still make out my case for corruption in the first instance. This takes me to another very critical point today, and I think it relates to one of the cases, right? Corruption is raised in almost every case. Almost all of it is dismissed, right? Just because you're not going to be able to either support your initial claim or you're not going to be able to meet this heightened standard. There used to be 2 cases. I think now, if we are generously interpreting things, we would say 3, 4 cases that have looked at corruption as a serious issue, but it's a very high threshold to meet. On your question on misconduct, right? Misconduct in an arbitration should not affect either the burden or the standard. The burden remains the burden, the standard remains the standard. Misconduct at best can be used to make an adverse inference, but more likely to assess costs, right? Tribunals don't have powerful arms. The only thing they can do is assess costs, and that can be a deterrent because, as we know, arbitration is not necessarily cheap, definitely not very quick. And so, investment arbitration cases can easily be in the high millions. Having a party pay one of that can be a sufficient penalty. But I'll stop here and pass it to Reika to see her reaction.
I really don't have much more to add. The 2 takeaways to me, as always, corruption is often raised, as Kabir said. Corruption is very difficult to prove. Full stop. So this is meandering reality of culpability. And what is appropriate evidence? And it takes us back to the rules, right? The rules let the evidence in. What evidence do you really use to prove up your case? That's tricky. So, good luck, even with good records.
Right, great, thanks. So actually there are two questions. I'll take one, I'll relay the one which is actually on the chat to everybody from one of our students, Sinhani. And it says, from your experience, do you find a commonality in all your cases? Are some cases most serious, like quasi-criminal ones, and how frequent are they in the realm of arbitration? Furthermore, do you think arbitration methods will become the ideal dispute resolution mechanism for civil and family matters as opposed to lawsuits and trials? It's a very general, non-related to the topic style question.
Yeah. I mean,
Yeah.
Reika, you should take this first.
No. Well, I was actually going to flip the order of the question because we haven't gotten to this nuance, right? This idea of a mechanism for civil and family law matters. And I was just going to weigh in. To me, this is hyper jurisdictional, right? It is common custom in some jurisdictions that you do take family matters to arbitration, but in others it's thought of as unconscionable because this is the family. It needs to be a protected space, much like children. And so I think that question is really tough to respond to, although you all are soon to become or are already arbitration practitioners, right? We want our pie to keep getting bigger. But the truth is cultural customs become hugely important in this aspect. And to me, this speaks much more to domestic arbitration practice imbued with the cultural overlay of where is it, which jurisdiction, and much more difficult, and probably wouldn't even necessarily enter the realm of international arbitration. I don't think we would necessarily get to this family law matters in an international context, far too complicated. But with that, I just wanted to flip the question because we hadn't gotten to that. But let's go back to this criminality or quasi-criminality. And I'll just add, claims of criminality or corruption, as we've said, they're often suggested. How common is it? I'll let Kabir weigh in as the practitioner on these kinds of cases. But just because you say it, you have to prove it. And to me, there's a very interesting sort of parallel to, in the same way during pandemic times, if you're going to make a claim of force majeure that you're unable to act because of the pandemic or otherwise, good luck proving it, because it's a high standard, not in any way to amalgamate criminality with a force majeure, state of emergency. But this notion of high standards, and just because you say it, you better have the proof to back it up, or you will lose, and you will lose favor with the tribunal, because ultimately it's about reasonableness in our practice, right? Just because you have a claim that you can argue, if you can't get forward with it, does it really make sense to go down that route with the tribunal and the parties and everyone spending time towards the benefit of your case and your client? But I'll pause there. Kabir, please.
I mean, commonality is hard, right? Because your cases can take such a wide spectrum, as Reika said. In investment arbitration, you see corruption cases being alleged all the time. Again, as Reika said, they're very seldom successful. You have to query whether it's worth bringing an objection that you're almost certainly going to lose. Could arbitration be used in family law matters? In civil matters, well, if you're talking about civil in the sense of civil disputes, contracts, torts, yes, you can. Family law, again, I think Reika's answer was the answer. It depends on your cultural practice. In the US, you do see, division of assets often taking place through arbitration. But then I think in the US also, divorce may not be seen as negatively as it might be seen in other jurisdictions. You don't, although if you want to keep things private, arbitration is likely a better way to do it than going to a court where everyone likely can gain knowledge. But, there will be a cultural component here. So I think, it's going to be hard to give an answer at a super macro level.
And the other quandary becomes, to me, administrative versus ad hoc, right? Because when it's so sensitive material, how do you go about it? And if it ends up being ad hoc, how much stats do we really have on this to understand a common level, even if we are particular to jurisdiction. That's where it also gets tricky. And that's how you have to think about towards party autonomy. What do they want? How is it done? How are metrics culled? Are they even available to be culled? When you think about the context of versatility and resilience in arbitration.
Thank you. So there's a couple of more questions now I've received. I think I'll take the one from Kaushik. Kaushik is a student at the Christ University School of Law, and he's the person in the Gryffindor scarf, so I will take his question. That's his picture. So the question again is not too much about the conversation that we've been having, but the question asks, how should the courts then deal with confidentiality concerns like they arise in the Amazon Future Group saga, something that's happening here in India, non-stop, still going on?
I don't know what's happening in India, so I'm going to tread here very carefully. Look, courts are going to have their own procedures. In the US, when you're going to seek an enforcement, your judgment is under default going to become public. That is the US procedure. How do we figure out all these cases? You figure out all these cases, arbitration cases, when they go to New York to get enforced. That's how they become public. Are there processes to seek confidentiality of an arbitral award in the US? I think the answer is yes, but it's done with very great reluctance. You have to meet a very high demanding standard. Now, I don't know whether this is relevant or not in the Indian context, but I will note that, if you look at the Aadhaar card and the debates you have in the Aadhaar card in India about privacy and all that, the equivalent I would draw in the US is Social Security, and we don't think ever about that in the same terms. So I think some of the debates in India have a very specific Indian connotation. I pivoted, but I thought that's a good analogy to see how somehow these things become very macro, top of mind issues in India. I'll stop here and pass it to Reika to see if she has any reactions.
Confidentiality is going to become an increasing quandary, right? And so it's an interesting question, and maybe one that you think about drafting on, taking the case example that you cited to, which I also am not as familiar with. But in general, right, what else are we seeing? We're seeing life sciences disputes and licensing disputes under that nomenclature come into arbitration as well, where they didn't necessarily used to, but there is now a pipeline even more so. Major confidentiality concerns, right? Patent disputes. Why are they ending up in arbitration in the first place? Because of perhaps this reality of protection within the arbitration realm. But then when they go to set aside annulment, enforcement, it could open up. And so what are the protections that they're trying to implement? What are the concerns? How do they get there? And I think confidentiality is hugely evolving in parallel with data privacy, other regulations. And there's a lot to be said, but it's really difficult to come out just with a clean answer on this. I'm sure you can appreciate, because again, we get back to really distinct and dissimilar standards.
Reacting to the chat.
Yeah.
This Sonali was our inaugural. See, nice CADR plug I have now for the audience. Sonali was the inaugural lecture that we did at the JGLS CADR in early February this year. So I've linked people to the YouTube. It's a lot of discussion on the lecture is about the ongoing Amazon Future Group dispute and about emergency arbitrations, etc. So you can go look it up. Right. I think we have one final question. Hopefully, we are not making you stay too much, maybe 5 more minutes, if that's okay.
Sure.
One final question we have from Ankit Malhotra. I think he's also a student here at JGLS. In the one MDB Malaysia scandal, money was siphoned from the public on the pretext of investment. In cases such as these, where the heads of state are involved, how can evidence be accrued? And if so, how can it be used in relation to the legal instruments available? And can international arbitration be used for recourse?
So there's a lot there. On the heads of state issue, heads of state can testify, and there's no prohibition on that. if they are directly germane to the dispute, give a witness statement and you can be called for cross-examination, or we can do it virtually. The travel component can be reduced to it virtually. If the head of state directly cannot testify, you can get other key people involved in it, in or around the president, who can testify. But there is no prohibition, or there is no special concession going to be given from an evidentiary perspective for the person who needs to testify. If you don't have documents, you need evidence, and if you need evidence, the appropriate people have to give the evidence. Can arbitration be used? Yes. I mean, I think arbitration. So there's a follow-up question. They waive immunity. I mean, we're not a criminal body, right? Your general immunity would be for criminal matters. I am not, as a tribunal, going to anyway be arresting you. It is not a case against president. It's a case against the state in an investment dispute. So I think the waiver of immunity, you'll have to see how it's going to play out. But we're definitely talking about action of the individual versus action of the state. Could you arbitrate a criminal law matter? I think the answer is no. You cannot. That is a no-go area pretty much everywhere in the world. So I think, give the evidence when it is appropriate. Yeah, I don't know if I have more to add there. Reika, any reactions?
I don't think I have anything more to add there either.
That's a tough one.
Yeah.
But tough questions are good questions.
Yeah. I think Ankit, if I'm not mistaken, he's the student head of the JGLS, the International Law Center, student-run center, I think. Am I right?
Well, that's very right. Thank you so much for this opportunity as well. Sir, thank you so much. It's an honor for you to hear from you again. I mean, I get the opportunity to hear from Chizugul on a monthly basis because the amount of lectures he does, I'm grateful to him. This is in fact something I was studying very recently. And as you were in fact answering the questions, this came up, and I thought it might be interesting to hear what you have to say. I'm thankful to ma'am as well for organizing this wonderful lecture, these wonderful speakers. Thank you so much.
Thank you. I think we can close on that note. And thank you so much. Thank you, Kabir. Thank you, Reika. Thank you very, very much. And thank you, Kabir, for getting Reika to do this with us. Yeah. I mean, I can always count on you even in the last minute. So thank you. You've always been extremely magnanimous and encouraging of whatever I'm up to. And I won't take too much time away now. It's way past breakfast for you. So have a good day, everyone.
Well, we want to thank you. I mean, it's always a pleasure. You all have posited some really thoughtful questions that I think bode deeper evaluation that we couldn't get to in the way we would have liked to in a chat like this. But we do encourage you, there are so many publications out there. Take one of these questions, dive deep, be thoughtful, and get yourself published. The other thing I guess I wanted to underscore, and forgive me for the sort of pitch, this group that we recently created, Racial Equality for Arbitration Lawyers, the real importance is that we figure out how to build a community, and we don't build that community at the outset at the global level. You have to start at the grassroots, at the localized, at the regional level, because diversity and racial equality mean very different things in very different jurisdictions. To that end, where you're searching for a community, and this becomes important, right? Although Kabir and I wear many hats, our goal is always to try to unify those hats and say, how can we do it better together? Be circumspect about the organizations you join. And if you're going to join them, make a difference in them. Don't just sit with your camera off and you don't talk, and it doesn't help anybody, and it's not worth any fee if you have to pay it. But to the degree real percolates with you in any way, please visit the website, it's in the chat, and think about it. And if it's not real, no big deal, no harm, no foul, right? But join something that you identify with. The most amazing part of international arbitration or arbitration at large is the community, whichever community you choose to thrust yourself into, and it is to go beyond your borders, right? We are in a cross-border practice. We bring in our own paradigms from our jurisdictional practice and the laws that are imbued in our own countries, but we get to the grandstand stage, the international stage ultimately. And so it's just more so, I say this all the time, you know, Kabir and I chat about it too, but pick your community, whichever pod you want within arbitration, and commit to it. And just, it's so exciting, even in the pandemic, or maybe even more so in the pandemic, as things, you know, are happening all over the world that are segmenting populations. People are much more open to sitting down and having a coffee with you. People that you admire, people that you've read about, people that maybe you've quoted for a moot that you've done. Reach out, because now is the time for you to build your trajectory. And I know that's like a public service announcement, but I say that to you, and I frankly say it to myself, and I try to put it on my to-do. Reach out to one person you've been meaning to be in touch with this week. Just one. It's not a big ask, right? Make one small change. We said that for Earth Day. Make one small change in how you go about your days, or otherwise they're just unending blurs. And we'll come out of this pandemic, and we will, you know, in 1+ years' time. And what will we have to show for it? So anyway, with that, it's been such a pleasure to beam in with you, and just such a pleasure to be invited by your professor. So thank you.
Thank you, Reika. That's a brilliant last word to have. And it's just something that all our initiatives at CADR are also trying to cater to this, bridging the gap between practitioners elsewhere in the world and our students mostly in India. So thank you again for doing this. We'll take your leave. Stay safe, everybody. Bye-bye.
Bye.